Calculate. 8. We elevate. 8. We innovate. But above all, we dominate. Capitalk 100.4 FM at 8. Harari's heartbeat. #dominate.
On the bar with Rumbidzai Venge, aka Legal Bay.
So happy to dive into tonight's edition. Good evening, Jirise. How are you doing?
Good evening, Rumbi, and good evening to our listeners. I'm doing fine.
Wonderful stuff. Good to know that you are with us. We missed you last week.
Yeah, sure. I had a problem with my car on my way to the studio, but it's now fixed up.
Wonderful stuff. Tonight we want to delve into a really, I don't even, I think even saying things are menaces now is losing meaning, because there's so many things that you can that you can think about and say, I wonder if this is a menace. But there has been a lot of arrests being made in the realm of sexual offenses that are being committed by minors, with minors. And in particular, what we found quite interesting, and I'm sure you've also had sight of a statement by the National Prosecuting Authority around an incident in Chipinge. It starts off by describing the perpetrator as a 16-year-old man. And then several sentences later, it talks about a 15-year-old minor. Let's look at that. What is the legal definition of a minor in our jurisdiction in Zimbabwe? And, what would a 16-year-old be called? Or why is this 16-year-old in this case being defined as a man?
All right, thank you, Rumi. The starting point is when we are talking about a minor, or who is a minor and who is a major. That position has been clearly defined and stated from the beginning with the supreme law in the land, which is the Constitution, which has placed the legal age of majority to be at 18, meaning to say a person who is 18 years and above is a major, and any person who is below the age of 18 is a minor. So that position is actually, I think, almost all of our laws, the Children's Act, the Maintenance Act, the Matrimonial Causes Act, the Marriage Act, our criminal code, and almost all the legislation that deals or defines young persons or children have been aligned with the Constitution now to state that a person who is below the age of 18 years is considered to be a child. So the real and the proper reference should be a child who is, as long as the person is below the age of 18 years, then they are at law referred to as a child. So in this regard that you are talking about, I think the offense which was this 16-year-old was charged with is Section 7, the popular. I don't know if we should call it the popular or the unpopular.
The Menace Act. What is this, menace?
Yeah, which is basically the crime of having sexual intercourse or performing indecent acts with children between the ages of 12 and 18. So, if you get to engage in a sexual act or indecent act with any person between the age of 12 and below the age of 18, with their consent, then the offense is actually what is famously referred to as Section 70, because that offense does not require the consent. It says even if there is a consent, then you are still liable. So of importance is subsection 3 of that section 70, which comes in to talk about children, and it clearly talks about children being involved in having sexual intercourse, and then it goes to scenarios what should happen when both parties are children. Remember, we have said children are those who are below the age of 18 and above the age of 12 for purposes of Section 70. And then what will then happen, there is an age difference or age variance of less than 3 years between these two children, or if one is a child and the other one is a major, but the age difference is less than 3 years, then the offense will be dealt with differently. But the bottom line is that we cannot refer to any person who is below the age of 18 as a man or as a woman. They are children. It's a child.
And just taking it a bit further, Kuda, does then using the term man in the present context have any legal implication regarding the offender's age and status? Kana tato muti murume zvine zvazvinobvisa here pa kodzero dzake okay, you hear what I'm trying to say. Kodzero dzake dzekuzvidzivirira, in order to protect himself.
All right. I think it does have an implication, because once we are referring to the child as a man, it means we are putting that child in the category of adults. Hence, we are saying they are supposed to be treated in any event as adults. You would notice that the law that we are talking about, the Section 7, there is a subsection there that actually provides that there is an additional requirement to consider any other law relating to the prosecution or charging of children, which should be taken into account should there be a decision to proceed with prosecuting such a child. So the child should continue to be protected and be treated as a child. So the law is coming in to say, even if they have been found to be in breach of the law, which may warrant prosecution or for them to be charged in a court of law, still they should be treated as children in those criminal proceedings or in those when you are conducting those charges. So I really believe, in my opinion, that the prosecution in this regard, with regards to the present case, it's not proper. What they did is not proper. It's somehow derogative to the child in question. Even if they had followed all the procedures that are required for them to proceed with the charging and the prosecuting of that minor, and still he was still protected as a child. They still were obligated to proceed with the same as a child. And I would present and submit that I think it offends the intention of the legislature for such a child to be referred to as a man. It defeats the whole purpose.
And going into the legislature, let's look at, how cases like this should be dealt with, particularly where, both of the parties involved are juveniles. They're both under the age of 18. There's a boy and a girl involved. Vabereki vemsikana ndo vanotomira kumberi vachiti aiwa mukomana ngaasungwe. Let's look at that as something that's actually happening in our reality day to day. Inofana unga ichitariswa senya yakadaro. What does the law say, and how do laws regarding consent, I think you did cover that when you're looking at Section 70, but just applying the law to this case, and izvozvo zvekuti vana vadiki vese vari kunzi vaita mhosva. Handiti mhosva?
Yeah, this was all right. I think the law is very clear on the procedure that is supposed to be taken there when two children are or both the parties are children. That is, they are below the age of 18. And then, if their age difference, like in the scenario that we have, if their age difference is not more than 3 years, then neither of them shall be charged or prosecuted. This is what the law provides for. Unless the prosecutor general, after considering a report that is given or submitted to him by a probation officer who is supposed to be appointed in terms of the Children's Act, has then authorized the charge. So what happens is that if the two minor children are involved in sexual intercourse, and what should happen, regardless of who has reported the matter to the police are not supposed to effect an arrest. They take these two and then they go with them to a probation officer, who in our case will be from the social services, and then a probation officer will write a probation officer's report after interviewing, and they do their own processes. So a probation officer will write a report and then submit the report to the police, and then the report is attached to the docket, which is then sent to the prosecutor general. So the prosecutor general will then consider the report that is submitted to him by the probation officer. In essence, the probation officer indeed can give a recommendation that a child be treated as if a major for the purposes of the crime. Anoita assessment yake anoti wonku uyu munhu asati 18 years, but I have considered 1, 2, 3 things for me to say they should be held accountable. One is Avanotaris. Kana kuti anoti, well, these are just innocent children who were just playing, and there is no need to prosecute either of them. So depending on the recommendations the probation officer report yake, the prosecutor general would then make his own assessment and then give a recommendation to say should there be should a charge be preferred against any one of those children or not. But this is how the procedure or the process goes on.
Quite interesting, Kuda. And just to gather that, there's an option by the prosecution to actually prefer charges. It's not automatic. So I'm happy that you've canvassed that, as well as looking into the specific charges, the procedure, whether or not charges will be preferred. Let's move into, a space where, say, for example, charges are preferred. Let's also talk about whom the charges are preferred against. What does our law say?
Sorry, I didn't get the question.
In the instance that charges are preferred and are put forward, who is being charged? It
then depends. It's not automatic. Remember, I said these two minors, one on a subject of kuna probation officer. Saka, it depends with the probation officer upper report who between the two should be charged.
Hey.
Or who between the two ndiana ufana kutitwa as an adult. So it's not automatic again kuti mkomana ndiano charged. Or in this instance, the age difference probably it's with months, because the guy is being said to be 16, the girl is being said to be 15. So they are almost the same age. So it's not really automatic to say if the boy will be charged or if the girl will be charged. It then depends with the assessment in Engeaitwa na probation officer. Obviously, achitarisa kuti conduct, past conduct, and what have you. They have their own considerations, not only in relation to sexual offenses, but in relation to any and every other offense. I can give you maybe a guidance. Yes, and now, yokuti yes, munanengare minor 16, 17 years, but akasosiya chikoro paakapedza grade 7 haaendi kuchikoro, anongogara. They are already into drugs. Akatombo convict of another offense, yanga ari jointly charged nema-armed robbers, but akaspewa jail because ainzi achiri mwana aendeseke kujeri. So those are the circumstances dzinotariswa, you see, and say for all intents and purposes munhu achiri mwana mudiki, but behavior yake yakutoradza kuti akatotora advantage akavictimize this guy or this girl, because if we look in the totality of the person we are dealing with, we can see kuti ndiye perpetrator or ndiye aggressor in this whole kind of a setup. So it's not defined to say is the guy who will be charged or is the girl who will be charged, but each case will be dealt with on its own circumstances and merit.
And each case is different.
Yes, each case is different.
Now let's move into that same, I suppose, analysis, that same discretion when it comes to sentencing. I also imagine that the same considerations are viewed and gleaned when it comes to actually sentencing, minors or any perpetrators in these kinds of cases. What are some of the differences, if any, in sentencing processes between minors and adults in cases of sexual nature?
Okay, to begin with, we have these sexual offences, especially most of them, rape, aggravated indecent assault, Section 70 and what have you, which some of them they provide for minimum mandatory sentences, some of them they provide for maximum mandatory sentences, and then we in our days now we have the sentencing guidelines which provides for the presumptive sentence, which every court or judicial officer is obligated to follow the presumptive sentence yakataurwa. So if the presumptive sentence is 10 years, give as an example, any judicial officer arikusentence munhu anoguidwa by that, and akadepata either departure yake iri yokudecrease yekudzikisa makore ayo kana yekuma-increase, anofanira kupa justification yekuti why have they departed. So there are cases that require special circumstances and not justify a departure from the normal sentencing trend or the presumptive sentence. And in this case, when we are dealing with minors, it's one of the special circumstances. It's known that we can't be sending vana vari below 18 years to jail because it will only expose urikunogarisa kujeri nema adults, some of them hardcore criminals and what have you. So you will be destroying them instead of rehabilitating them. So the main focus when you are sentencing minor children is to rehabilitate, is to restore them, and so mostly the sentences andarekuwa kuma rehabilitation centers, or in this instance we saw them a sentence of 4 years wholly suspended. And then on the usual conditions within that period committed that offense. In my opinion, I think it's not that sentence will not help this young man. Let's forget about whether or not the charges were properly preferred. But I think the sentence itself does not really serve the purpose. Remember the last time we discussed about pretrial diversion, and for children to say there should be a different route inotorwa to deal with especially minor offenses anenge akomitwa nemaminor vana vachiri below the age of 18. They should not be brought to court. Could be that subjection in its own is traumatizing. It will damage them more. Yet the whole intention of applying the law and charging them is mainly to restore and rehabilitate those offenders. So basically, when we are dealing with minors, in most instances, especially if they are first offenders, or kune mamwe centers around the nation where they will serve a sentence, but equipped with a skill, they will be doing a course, they will be doing something there, so that especially in these sexual offenses, most of the times it's because of idolism. Like yandanchitaura yekuti munhu anenge akaita grade 5 achaende kuchikoro arongogara kumusha, and they have nothing else to do except maybe looking after gods, and then ndo panozopinda these minds dzekuti anozopedzisira akuita indulge in sexual intercourse with other minors and what have you. And so the whole idea is to remove that mindset and probably give them something to do, that they will do something with their life. It's not necessarily to punish them. Strictly, when we are dealing with minor children, the whole reason behind sentencing them is not to punish, but is to correct and rehabilitate.
Really interesting, and it's good to hear that tinototanga ndechekuti ngatigadzirise munhu tisati tamuisa muusungwa maanogona kuzotodzidziswa criminal activity chaiyo. So when a sentence is wholly suspended, for a period of 5 years, for a certain period, in this instance the offender was sentenced to 4 years in prison, wholly suspended for 5 years. What does that mean, and what are the conditions upon which a sentence is suspended, either conditionally or wholly?
All right, depending on the circumstances, like we were saying, I was saying earlier on, a sentencing officer kana koti chisentensa munhu ine maconsiderations ainoita anosanganisira kuconsider mitigating factors and aggravation. Mitigation ndo mafactors aripo kuna offender anoita kuti tikaatarisa tinoti munhu uyu aakodzeri kuendeswa kujeri, pane zvinhu zviripo zvinoita kuti timupe mutongo wakareruka. Anonzi ma-aggravation factors ndeaya anoita kuti mutongo ureme. In other words, sometimes, to give as an example, but the moral blameworthiness yake yakati kurei. For instance, munhu in the sexual offenses, munhu the offense was perpetrated to a close relative, a sister, a parent, a brother, something like that. So it becomes aggravatory because the moral blameworthiness is in our account for people of that degree of relationship to indulge in sexual intercourse. So it becomes aggravatory in way. But when we then say everything has been considered, the point that people sentence like our instance depends in the offense yacho, because these offenses, a person who is guilty will be liable to a fine of up to level 14, or to community service, or both community service and fine, or to imprisonment of mamanangacho provider up to life imprisonment or up to 20 years imprisonment. So the sentencing court in a discretionary so wide to consider kuti ndopa fine here, ndopa community service here, ndopa imprisonment sentence here, kana ndipa imprisonment sentence ndo suspend a portion yacho here, kana ndo suspend a yese sentence. All these are factors dzinenge dziri available to a sentencing court. Saka kana chiti a person has been sentenced and the sentence is wholly suspended for a period of 5 years, on the condition that within those 5 years the person does not commit an offense involving sexual intercourse, of which if they repeat or they are convicted of the same offense, they will then be sentenced to those 4 years without the option of paying a fine or having the sentence suspended. Trukuti isusu munhu arikufamba hake mumastreets asi akatakura makore 4 kujeri akangoita mistake adzokorora, kuita offense yakada kufanana neiyoyo. For the next 5 years, there will be a suspended sentence that is hanging on their shoulders. That's why I was saying, in my opinion, this is not an appropriate sentence. Because a 16-year-old does not appreciate a suspended sentence on my shoulder. Sentence is supposed to make sense to the offender. I would have actually said it was better to have people community service. When I wanted a community service, 240 hours of community service at a public institution. It's much, much better that way, rather than to give a 16-year-old a suspended sentence. It's a personal opinion. In my opinion, I don't think this sentence serves the purpose within which the sentencing guidelines are provided for in the court.
That's Kuda's opinion, as he says, and we are opening up our phone lines as well as our WhatsApp platform for your comments and questions on 0719 100 404, 0719 100 404. Kuda, we've got a number of questions, and I'm looking at our time. I think we are better served looking into some of the issues being raised here. Tatenda Suvo says, hello. Mutema wedu in Zimbabwe, as long as uri murume, it won't be fair towards the female. I don't know why our government always suppresses my organizations. Ese anomirira the boy child. It's all about protect the girl child. It's okay. So wazara mkomana, anzi wazara mkomana ya mosha nai, considering ava vana vese they agreed. Let's take two 15-year-old boys and a girl. We can find with a girl anenge to be more mature than a boy. Akutoziva to look after herself nekodzero dzake, because we don't have organizations anona for the boy child could anokurao say and could kunze kunei. Okay, that's one view. Here's another one. Patrick says, challenge at Titan Day, our laws are there to protect women and make sure that as many men as possible get thrown behind bars. Why should a 16-year-old boy be arrested and this 15-year-old girl is let go? If we want to apply the law, why not apply it to both parties? Age difference, you may find it's just a few months. But mkomana atosungwa kuti jitakure uremu, aba anzi 16-year-old man. I wonder, how they can call him a man yet pamtemo vachiti he's a child. Maima Tipa says, in Anzi probation officers tisuma social workers Maizoe, I'm loving the conversation. And she says in most cases vanopi wa counseling hapana anosungwa zvake pama juvenile delinquency tinomati ma JD asi anotovurirwa file rake. The last message I'll read here is from UP Kennedy Ishmael, who says they tend to be more focused on the girl compared to the boy child. There should be more laws put to protect the boy child, as they tend to be left in the cold to find their way, if at all they can find their way. And then Mainoku Pamrewa says, ko muskana akaitiswa pamwiri, anti muskana is disadvantaged too. Quite an interesting crop of views from our listeners. But there is that concern you're hearing there, Kuda, about equal representation, equal protection of the law for boys and girls when it comes to naudza kadai so kunyanya. What are your comments? And also just, coming back to that aspect around izo zofungwa dzekuti vamwe vanoti but vakomana vanenge vasina kunyasa kudzivirirwa nemutemo kupfuura vasikana.
All right, thank you, Rundi. First and foremost, I think in terms of our laws they offer equal protection. I don't think it's correct to say our laws are discriminatory. They are not in any way discriminatory. If you read all our laws to reflect, like as I was saying, even the criminal law codification and reform, any other law that relates with children, it doesn't even genderize. It says a child. And then the protection is being offered to both sides and both parties. Where I want to draw our listeners' attention to is the issue yandataura yekuti vana ava vanoendeswa kuna probation office. It's the probation officer's assessment. So we should not just use this one case, because there is a reason, probably. I'm not privy to the whether it happened, whether in this case, probation officers report or what. I'm not privy to that. But it can be the probation officers report it in a factual findings. In this instance, the boy was the aggressor. The boy should, for all intents and purposes, be treated as a major, so that the law will correct him. I would like to think in that instance we don't need to invoke the question of gender. And I would also want to put a comment and say I don't think our government Rumbidzai any organization in the boy child. I think they are there. I know of one organization that is there. It's a question of their heralding and the noise that they make, the activities that they do. I may as well agree that there is so much talk for the boy child's rights, raising up a boy child, as much as there is that talk about the girl child. I think the historical background have an effect on this, because historically, if the girl child was neglected, is the girl child who didn't have equal protection, is the girl child who was not being given equal opportunities as was being given to the boy. So this was reactionary to redress the anomaly that was there. So my women's organization, Anonira Vana, and the like, akabati boom, akabakura. But in so probably that's the reason why the scale is tilting towards the protection of there is more talk about the protection of the girl child. But in terms of our laws, they protect a child as a child. And this is the reason why, for purposes of Section 70, the law provides for sexual intercourse or indecent act. Kuma indecent acts kazinji anoitika against the boy child, not against the girl. But the law is just coming in and then providing protection for all of them. So in terms of the law is protecting all of them. In terms of application, probably one or two people may actually feel that there is no equality, or there is this sidelining of boy child. But I think we need to, before we make that conclusion, especially what case study today, we need to have an idea and knowledge and background of the fact that kuti mukomana azochargwa musikana aregedze kutargwa. It's not automatic kuti akangodzi nekuti mukomana, but there is a process that probably was followed, and I submit that a process that should be followed, as I have already submitted. And I like it from our listener who is a probation officer, Aita Kamina Akati. We deal with this, and in most instances, Chinoapa counseling, where then we put those reports in their files and submit. Those reports are submitted to the police for purposes of my dockets are closed, and what beyond this matter was dealt with. That's the normal procedure. But or the usual procedure that is taken. But in the present instance, we don't know now what prompted the Prosecutor General to then proceed with prosecuting. And maybe it's unfortunate that highlight by the NPA is not giving us full information of whether or not there was compliance with that need of a probation officer's report, and also to seek consent of the Prosecutor General.
Wonderful stuff, Kuda. We are right on the nose and we've fast run out of time. Panemunanga unza omwenye, it is very interesting, of the 84-year-old woman who was sentenced to 15 years in jail for abusing a 17-year-old boy. So perhaps a story for a different time. But thanks so much, Kuda, for all of your insights on this one. And I certainly hope that our listeners are better informed. You know, maybe it might be a typo. You know, we'll reach out to the NPA to find out that whether it could have been a typo.
To do that.
Absolutely. Sure. But let me thank you, Kuda, for your insights and for your time. Let's do this again next week. Have a great evening.
Good evening, Ruby.
Thank you so much. And with that, we are right at the top of the hour. It's 7 o'clock.